And I'll recognize the gentlelady from Wyoming, Mrs. Lummis, who is a former member of this committee, and you know the rules because you've been on this committee, so you're recognized for 5 minutes.
Well, thank you, Mr. Chairman, Mr. Ranking Member, members of the committee. This is the third time today I've missed being on this committee, and this is only my third meeting of the day. So thanks very much for allowing me the opportunity to speak today. After listening with great interest to your committee discuss litigation as part of your hearing on the Endangered Species Act a few months ago, and especially now, after the senator from Alabama has delivered forceful remarks on the need to update and modernize the Endangered Species Act, I thought it important to share with you what I have learned on taxpayer-funded litigation. Understanding the types of litigation and the source of taxpayer funds for each is a critical first step to fixing any problems associated with litigation. So with your indulgence, I want to use my time today to help set the stage for your important deliberations. Title 16, Section 1540G of the U.S. Code is the law that authorizes citizen suits in the Endangered Species Act. Suits filed pursuant to this section of law are awarded fees and expenses through the Judgment Fund, a permanently appropriated bottomless pot of money established for the purpose of paying judgments in suits against the federal government. These citizen suits and decisions about when and how much taxpayers should be on the hook to pay for them fall squarely in this committee's lap. It is critical that you take up this issue because I strongly believe that the court is not the right venue for ensuring successful species conservation. But regardless of what you decide to do or not do about ESA authorized litigation, the fact remains that Congress has clearly spoken about what types of litigation are appropriate under the ESA. Now, that's a fact that's important to distinguish the ESA litigation from Equal Access to Justice Act, or EAJA, litigation, as it's known. At its core, EAJA is a social safety net program, not an environmental one. It's designed to reimburse individuals or small businesses the costs for attorneys that sue the federal government when no other law provides for that. The congressional record on EAJA's development and passage is crystal clear. Congress intended that it serve as a way to help veterans, retirees, and small businesses combat the federal government in court when they felt they had been personally wronged. Unfortunately, the law throws up difficult roadblocks for these legitimate users to recoup their costs. Those roadblocks are virtually non-existent in environmental litigation because of the difference in the types of cases brought to court. There's ample documentation that EAJA awards in environmental cases are exponentially larger than in cases involving our nation's veterans or retirees. I want to refer you to scholarly journals from Virginia Tech and Notre Dame, reports from the Government Accountability Office, and review of tax records and open court documents to confirm this. All these reports show that despite Congress's clear intent, EAJA has been used to reimburse groups for environmental lawsuits, and no one in government is keeping track. Contrary to lawsuits filed pursuant to the ESA, EAJA reimbursed lawsuits that touch on ESA decisions are not related to actual environmental violations. Now, let me say that in a different way because it's a critical point. In every single EAJA as opposed to ESA related cases, litigious environmental groups are paid not because they found an environmental violation, but because they dispute the paperwork or procedure by which the government reached a decision the environmental group opposed. In essence, these groups use EAJA as a taxpayer-funded backdoor approach to protesting agency decisions and altering the ESA's operation without ever having to prove a violation of environmental law. Litigious environmental groups like to say that EAJA reimbursements are a small part of their budget. If that's true, then they won't miss the subsidy when it's gone, but either is a weak argument for the point. Environmental laws exist for environmentalists. EAJA is for seniors, veterans, and small businesses in need. because EAJA payments are supposed to come from agency budgets. Every single dollar paid to support court battles over procedural grievances is a dollar not spent on actual recovery. We've lost sight of that, and we have let litigious environmental groups exploit our lack of vigilance. Mr. Chairman, I would refer you to my additional remarks in writing, and I deeply appreciate this committee's time and indulgence to understand the distinction between ESA litigation and EAJA litigation this morning.
Great.
Thank you.